that somebody from DOJ is here?
Yes, if you're from the DOJ, great, could you raise your hand again? So that if folks have questions after this, then I hope that you will feel free to address you. Can you tell us your name, please?
Yes, hi, I'm Adrienne Brown. I'm an assistant U.S. attorney at the U.S. Attorney's Office here in Portland at the Federal Courthouse, and I'm working with the Civil Rights Division on the case. And yes, I'd be more than happy to answer any questions. Thank you. Yeah.
Could you please
Sure. Hi, yeah, Ellen Osenak from the City of Portland at the City Attorney's Office, and I'd also be happy to answer any questions that folks might have about the case.
Thank you.
So again, I know the lawyers here, so I have to be really clear about what I'm saying. The letter of findings was the outcome of the investigation. They said we looked at these different incidents and we found a pattern of practice where the police are using excessive force against people who may appear to be or are in mental health crisis. And it is a 40-page document, but basically the outcome was they found this pattern of practice. In the letter of findings is a description of the oversight system that we're talking about. And this was the best flowchart they could find. I think you might have a copy of another one, which we have there in the center, which is a little bit more streamlined. But it is what they call this oversight system Byzantine and self-defeating because it's so complicated. So the next document was the settlement agreement. So anticipating that the result of the finding of this, of the letter of findings, was going to be a lawsuit against the city for violating people's constitutional rights, the city and the DOJ negotiated a settlement. And that went to City Council and was voted on November 14, 2012. After a little bit of discussion, there were a few tweaks made between the first presentation and the second. But, this is a 77-page document. We're going to be spending most of the evening talking about that. And then the third document is the complaint. So the lawsuit that says the City of Portland has violated people's constitutional rights of people who have or may have mental illness had to be entered into the court, and the DOJ is saying, we're suing you, City of Portland, because we found this pattern in practice. But Judge, we're not going to have a trial because instead of having a trial, we're going to make a settlement out of it. And that's the agreement, the settlement agreement that we're talking about, right? So and if the settlement agreement is not agreed to, like the police association until December wasn't agreeing to it, there would have been a trial. There would have been some motions and witnesses and all. So then there's two more documents. The AMA collaborative agreement, which is the one I described already, where I said the AMA is not objecting to the entrance of the agreement into court, and then the PPA's own memorandum of agreement, which also says they're not going to object. So again, you don't have to be experts on this. I just want to make sure you have a clear picture. You can switch to the next slide. Great. So now, Reverend Lauren and I are going to go over basically the blue fact sheet that everybody should have. And this is some sort of broken into sections about things that the AMA Coalition thinks are good changes, things that where the settlement went far enough, ways that the coalition feels the agreement accurately inhibits accountability, and places where the agreement is silent. So we're going to start with the good changes proposed section.
And we're going to ask that you hold your questions. We will have a place for question and answers, but this is, a condensed form of 77 pages, and we want to get through it with enough time for people to have their questions addressed and to give testimony should they choose to. So, good changes proposed in the agreement. The changes are being made to the Bureau's use of force policies, which was a concern, including that police must de-escalate their use of violence as the resistance from the subject decreases.
So the slideshow, which you also have a copy of it, I think, has the full text from the agreement in it, so that you can see, if you're interested, the details of what we're talking about. We're just trying to walk you through it briefly tonight. And generally, you can see pieces that we highlighted here. These force shall be de-escalated to resist decreases. So that's an example that hopefully will help you understand contextually what we're talking about. So the next one is officers who were found in civil court, who have violated someone's rights must be subjected to an internal affairs investigation, presuming that they're guilty of misconduct unless the evidence shows that they're not, which is a huge thing because, as you know, in criminal court, we're presumed innocent until proven guilty. But what they're saying is that if you sue the police and a judge or jury says there was a violation of the person's rights, then they're going to open the investigation as though the officer had a policy. And this is within this longer paragraph.
Also, and this is significant, the supervisors will be trained to conduct annual performances, reviewing the officers every year. And this was really good news to us because what we discovered is that there were certain officers on the force who were doing the same type of behaviors and not having consequences. And once they have a system in place where there's actual annual performance reviews, it'll put the city in a better position to alter some of